Welcome to the Digital Planning Podcast. This series is designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. To keep up with all things digital, please subscribe at iTunes, Stitcher, Google Play, or wherever you download your podcasts. And now, Jennifer Ziegel, a partner at Kleinbart LLC, Ross Bruck, a principal of Estate Genie, and Justin Brown, a partner at Pepper Hamilton LLP, with today's topic.
Welcome back to the Digital Planning Podcast. I'm your co-host Jen, and I'm with my co-hosts Ross and Justin, and today we're going to be exploring digital wills. This is going to be one of a three-part series. So let's first talk about what exactly is a will. So in general, right now, a will is a way to transfer and dispose of property. It's a fundamental right to dispose of one's property as one desires. And in the United States and in other countries, there are different formalities that are required in creating, executing, and attesting wills to ensure validity and also to make sure that the intended transfers are honored and respected and safeguarded to limit manipulation of a testator's wishes. Due to the rise of digital assets, cloud-based services, and technology, electronic wills are on the horizon. And there's a great divide among the estates and trust community on whether digital wills should be accepted, should be honored, or should be completely eliminated.
A great point to make regarding the state of digital signatures, electronic wills, comes from actually the real estate community. You can buy a house, you can get a mortgage without setting foot in the broker's office, without doing anything but leaving your computer. The rise of using electronic wills to file formal legal documents, make transactions, has become so commonplace that there's a expectance on behalf of consumers that they can do anything from their smartphone or their laptop.
And I think also younger individuals who are living on their phones or their tablets or computers, I think going to what you were saying, Ross, they have an expectancy that why couldn't I make a will on a iPad or a computer or my smartphone?
And there's actually a good reason for that. In 1999, the Uniform Electronic Transaction Act was put forth by the ULC, the Uniform Law Commission. It promoted the idea of the use of electronic transactions and electronic signatures. And then a year later, the E-Sign Act was put into place by Congress, which furthered the idea that electronic transactions would be recognized. With regards to the Uniform Electronic Transactions Act, or UETA, 47 states have adopted that language in some form or another. Obviously, the E-Sign Act is a federal law. Both carve out the use of electronic signatures for testamentary wills and testamentary trusts.
And I think that's important because I guess we as estates practitioners view wills as sacrosanct, and we have these specific formalities for executing wills, and each state has their own specific formalities, and it varies from state to state. So some states will require just a signature of the testator, some may require one witness, two witnesses, three witnesses, some may provide for self-proving wills, which are notarized. Some may provide for initialing on every page or signatures on every page. So it really depends upon what state you're in as to what the specific formalities are.
Justin, the word you use, sacrosanct, I think is right on the mark. A lot of estate practitioners look at wills as sacrosanct, as you said, but the average consumer might not share that belief or that mindset. They might view the priority being on the ability to transfer their assets from themselves to the intended beneficiary. And that is the most important aspect to them of estates and property law, the free flow and free will of transfer of assets.
And by having certain formalities in place, a testator is reminded of the gravity of the document and the transactions that could transpire to the testator's family when the testator is no longer here that can have far-reaching impacts.
So in recognition of the fact that sometimes formalities are not always followed, and the fact that they're not followed doesn't mean that it's because of fraud or undue influence or lack of capacity or any of those typical things. Sometimes just the formalities aren't followed. Many states have developed a harmless error standard. Not all, but many states. And the purpose of the harmless error standard is to provide, essentially, that if the testator intended by clear and convincing evidence for the document to be a will, an addition or alteration to a will, then courts in these states will say that the lack of formalities is simply harmless error, and they will respect the document in and of itself.
However, there are many states that don't have a harmless error statute. So we're in Pennsylvania, and Pennsylvania does not include a harmless error statute to preserve wills that might not have been executed with the requisite formalities. Interestingly, Pennsylvania is one of a few states that also allows holographic wills. And a holographic will is a will that is written in the testator's own hand and signed and dated by the testator. It doesn't need to be witnessed, it doesn't need to be notarized, but the proponent of the will, who's trying to admit the will into probate, will need to prove to the court by clear and convincing evidence that the holographic will was truly signed by the testator, and the testator had capacity and was free of undue influence at that time.
As Jen said, we're in Pennsylvania, but right across the bridge from us, New Jersey, does have a harmless error statute. And when that statute was passed, there were a lot of practitioners who were concerned that this was going to open up the floodgates to every kind of potential will that could be out there. And it has and it hasn't, but it's a great segue for us to go into electronic wills, because a lot of these electronic wills may be falling under a harmless error statute.
Right now, most states will allow wills to be thrown out and not admitted to probate if it can be proved that the testator didn't have the requisite mental capacity at the time the will was executed, or that the testator was unduly influenced in the events leading up to and surrounding the document execution. These issues and concerns are still going to be present with digital executions of wills, among some other issues that arise with this type of technology that we'll talk about in a little bit.
Now that we've explored the landscape of wills and electronic wills a bit, let's dive into a little bit more detail of what we mean when we say an electronic will. An electronic will is a document that is prepared on a digital platform and stored on that or a different digital platform, and is not a tangible object, never printed, never signed with an ink pen. It is stored electronically. And along with that comes, how is the document, how is the electronic will signed? And that could be a number of different ways. It could be just typed in, the testator's name typed in by him or herself. It could be written in with a fingertip or a stylus on a touchpad. And a document preparation software could also offer an electronic signature that is a script format of the testator's name.
So, Ross, also another type of situation that can occur with digital wills is when the will is signed digitally and the signature is actually verified by a third party. This right now is usually going to be a for-profit type of company that is doing this type of verification.
And none of this even covers witnesses or notaries, and we'll talk about that in a moment. But before we do, let's break down, now that we've covered the idea of how an electronic will is signed, let's talk about the different types of electronic wills. And for that, we wanted to reference a Harvard Law Review article titled "What is an Electronic Will?" which was published in 2018. And it does a good job of breaking down some of the background of electronic wills, as well as the types of electronic wills. And we encourage our listeners to go take a look at that article. But it talks about three separate categories of electronic wills. First, an offline will. So a testator uses a drafting software to create a will that is entirely contained on his or her laptop. It's created only on the computer. It's stored on that computer. It does not leave and enter the internet in any way.
It could be as simple as just somebody typing something in a Word document, and that Word document is stored on the individual's computer.
Or even simpler, it could be in a notes application on your smartphone that never actually leaves the smartphone, is only maintained in that format.
One of the problems with these offline wills is that what happens if your computer, which is storing the document, crashes, or it's lost, or if you have this stored on a note on your phone? What happens if you lose your phone? If any of these devices that are storing the offline will break or are lost, then you have essentially lost your will.
It also gives rise to the situation where there could be bad actors that are aware of the contents of the will that's stored on a tablet or other device, and when the time comes that would need to be probated or attempted to be probated, that bad actor might do away with the device, and there would be no other record or trail to show what the testator's true wishes were.
Even simpler, you also have the problem of a testator forgetting about an electronic will that he or she created in that format, making copies, not clearly understanding how to revoke that electronic will. Even away from any nefarious activities of a third party, the testator's own actions could be questioned when using an offline will.
Or even simpler, after the testator has died, does somebody else know that this will exists on a computer, tablet, or smartphone? And how do they access this will that's on the smartphone? So a second category of wills, so we have offline wills. The second would be online wills. And online wills would be wills where people are actually posting something on the internet or storing it in a cloud-based program, and they have the intent for this document to be a will. So for example, if we take our typical offline will, which is just a simple Word document on somebody's computer, and if the testator then moves that into a cloud-based account, they have moved it from an offline will to an online will. And essentially with an online will, it's no longer on an individual's personal computer, it's now stored on a server someplace in the cloud. Something like a Dropbox or an iCloud or some kind of service like that. Now, one of the problems with online wills is that you're now subject to the Stored Communications Act. And in one of our prior episodes, we talked about RUFADA, the Revised Uniform Fiduciary Access Digital Assets Act, and how fiduciaries may have difficulty accessing documents that are stored electronically, and the online wills problem just adds to the issue of how do we access these documents.
Absolutely, and to piggyback on that, whether the will would be stored offline or stored online, you're also going to have issues in an interplay with the Computer Fraud and Abuse Act that would determine the lawful rights to actually access the devices, which is overlaid with RUFADA legislation adopted in different states, which can have varying outcomes as to who legally can authorize that type of information.
And you're also subject to the terms of service agreement of the company that is storing this document. So if you're storing your will on Google Drive, then you're going to have to look at the terms of service agreement for Google to see what happens to that document. And upon the testator's death, maybe the terms of service agreement provides that all documents in that service provider are deleted, in which case we'll never be able to access the electronic will.
An interesting issue that could easily arise, especially with a Google cloud account, would be that Google is one of the providers that allows a person to establish an online tool and to designate who can actually access the information at the appropriate time. Now, if a will was stored in a Google Drive and the testator utilized an online tool, but the person who had the authorization for the online tool was different than the person who is actually named to be an executor or administrator in the will, it could have very unusual consequences, if not dire.
Right. What happens if the person named by Google doesn't like the will, and maybe somebody else is receiving more under the will? There's a disincentive to bring that will forward. Forgetting about fraud and forgetting about what they should or should not do. It's just what they could do.
And if they chose to do that and destroy the will or not bring it forward, how would the true executor ever be able to uncover that information?
But the same problem could exist in the real world. A beneficiary or someone who was not named a beneficiary could find an actual hard copy will of a decedent and disagree or be disappointed with what they see in terms of the dispositive terms of that document and destroy it or hide it or never bring that to probate.
Which is a good reason why people should have their original estate planning documents stored with their estates and trusts attorney.
Well, but I think that raises an important point, which is we by allowing these electronic wills, we're taking the preparation of these wills out of the hands of the attorneys, who are then presumably going to be storing them and placing it in the hands of the testator, who is going to be responsible for their own storage.
Which is a good segue to the third type of electronic will, which is a qualified custodian electronic will. And by that we mean a document that is stored and maintained by a third-party provider that the testator entered into a contract with. And that qualified custodian has to adhere to the rules and regulation put forth by the testator's state. So there is some sort of regulation that requires the qualified custodian to meet a certain standard and to maintain the document, which would hopefully eliminate a lot of the problems we identified in the first two types of electronic wills, both offline and online.
However, one of the problems with a custodian will is that it's still going to be subject to the terms of service agreement that you have with the company. So before somebody agrees to make their will with one of the, or have this company hold their will, they need to know what the terms of service agreement says, who can access that will, what the rights and responsibilities are of the company after somebody dies, and what the rights are of somebody who's named as an executor under that will.
I mean, I think the matter gets further complicated because states may have and will likely have different definitions of what a qualified custodian is, and if it's a third-party for-profit company, there's always the risk that the qualified custodian that a testator is utilizing could go bankrupt or could go out of business or could have a massive network collapse or shut down, which could affect all of the documents stored on its database.
So with all of these issues with electronic wills, there are some states out there who have gone to the forefront and either adopted or proposed legislation to explicitly authorize electronic wills. Nevada being one of those states which accepts electronic wills. But the Uniform Law Commission has been meeting to kind of craft some kind of electronic wills statute. Ross, what's going on with the Uniform Law Commission?
As you mentioned, the Uniform Law Commission has formed an electronic wills committee. They've been drafting a proposed act for just under 2 years. And there has been a great deal of discussion, both within the committee as well as outside the committee, about what exactly that act should say or shouldn't say. We expect to see later this year the first published version of that act, and it'll be interesting to see how they address a lot of the concerns that have been raised by the community regarding things like fraud, regarding things like all of the problems associated with that we just mentioned for each type of electronic will. And this is done in light of, as Justin just alluded to, States are actively looking at that within their own legislation. Nevada in 2001 was the first to publish an electronic wills law permitting the use and recognition of electronic wills. We are waiting for future development of the law around the country. And that brings up a good point of we may be in a situation in the coming years where some states have, in addition to Nevada, some states recognize electronic wills and others don't. What happens when people start to travel and have executed a valid will in state A and it's not recognized in state B, but the testator still believes that he or she has a valid will? What is the future of those probate cases?
Lots of litigation. That's the future if we don't have more of a uniform system to handle electronic wills. I think it's important to note with Nevada, although they are spearheading the movement of digital wills and created their initial statute back in 2001, it is not widely used right now in Nevada, and a lot of practitioners in Nevada specifically state on their websites and in dealing with clients that they don't prepare or assist in facilitating electronic wills. So it's not very common, even though it's authorized in that state.
Well, thank you everybody for listening to this episode of the Digital Planning Podcast. Stay tuned for our next episode where we're going to continue on the discussion of electronic wills.
Thank you for listening to this episode of the Digital Planning Podcast, the podcast designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. Please subscribe to this podcast and leave us a rating or review at iTunes, Stitcher, Google Play, or wherever you download your podcasts. Thanks for joining us. We'll see you next time.